Morning, everybody. Hope everybody refreshed, recharged, ready to go for another week in Ottawa. I want to call this meeting to order. Welcome to meeting number 32 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to the order of reference of March 24, 2026, the committee will begin its study of Bill C-235, an act to amend the Criminal Code increasing parole ineligibility. Today's meeting is taking place in hybrid format. Pursuant to the standing orders, members are participating in person in the room and remotely using the Zoom application. I would like to confirm that sound tests were made successfully. Simple head nod will suffice. Okay, thank you. I would like to make a few comments for the benefit of witnesses and members. Please wait until I recognize you by name before speaking. For those participating by video conference, click on the microphone icon to activate your mic, and please mute yourself when you are not speaking. For those on Zoom, excuse me, at the bottom of your screen, you can choose between floor, English, or French. For those in the room, you can use the earpiece, select the desired channel. Reminder that all comments should be addressed through the chair. For the members in the room, if you wish to speak, please raise your hand. For the members on Zoom, please use the raise hand function. The clerk and I will manage the speaking order as best we can. We appreciate your patience and understanding in this regard. So for the first hour, from 11 a.m. to noon, we have appearing today for the first hour is the sponsor of Bill C-235, the MP from Cowichan, Malahat, Langford, Mr. Jeff Kibble. Welcome and thank you for joining us today. The floor is yours for up to 5 minutes for an opening statement, and then we'll go to questions.
Thank you, Mr. Chair. I'd like to thank the committee for allowing me to be here today, and I want to begin by acknowledging someone who will appear before this committee on Wednesday, Ms. Landolt, Kimberly Proctor's aunt. She's agreed to testify because she believes Parliament can do better for families like hers, and I ask every member of this committee to hold that in mind as I speak today. Bill C-235 has been tabled in Parliament 4 times before. In 2019, it passed committee and was set to return to the House for a 3rd reading. Then Parliament dissolved. Progress died. Families kept walking into parole hearing rooms they should never have had to enter. I'm here today to make sure that that does not continue. Let me be precise about what this bill does and what it does not do. It does not create mandatory minimums. It does not impose new sentences, and it is not retroactive. What it does is give a judge tools, a targeted tool applicable only where abduction, sexual assault, and murder are committed against the same victim in the same event. And in those cases alone, a judge may, after hearing jury input, extend parole ineligibility from 25 years up to a maximum of 40 years. Full judicial discretion every time. That 40-year ceiling was not chosen arbitrarily. It reflects the consecutive maximum ineligibility periods for all 3 charges combined. The legal framework is sound. The bill was modeled after Bill C-48, the Multiple Murders Act, which has already survived a charter challenge. There is a further point that bears directly on that analysis. Where the victim has been abducted, sexually assaulted, and murdered, prosecutors routinely stay the abduction and sexual assault charges and proceed only on murder. Under the current law, conviction in all 3 offences yields the same 25-year ineligibility on the murder alone, so there is no incentive to charge all 3. Offenders are effectively sentenced only for murder, even when they committed 2 additional serious crimes. Bill C-235 corrects this. The extended ineligibility is not cruel and unusual punishment. It is proportionate for the 3 distinct crimes committed in a single incident. I have reviewed the proposed amendments put forward by the party opposite carefully. With respect, I do not believe any of them strengthen the bill. Some are legally redundant. The law already provides what they seek to codify. Some risk making the process more complicated than it needs to be, and some, I would suggest, come close to instructing judges on how to do their jobs, which is precisely the kind of judicial discretion this bill is designed to protect. I'm happy to speak to any of them in detail through questions from the committee. The heinous criminals that this bill targets are never going to be released. We have never found such a case. The parole board has been consistent. These are dangerous offenders and psychopaths, but they are permitted to apply for parole every 2 years beginning at year 23. And they use those hearings not to seek freedom, but to terrorize the victims and their families, to recite in gruesome detail of what they did, to force families back into that room and crime scene over and over. This bill eliminates an average of 8 of those hearings. 8 times a family does not walk back in. 8 times a sadistic offender cannot use the process as a weapon against the people he destroyed. 15 years ago, 18-year-old Kimberly Proctor was abducted, tortured, sexually assaulted, and murdered by her classmates on Vancouver Island. Her killers were charged as adults, but unusually sentenced under the youth framework, with no chance of parole for 10 years. That outcome falls outside the sentencing scope of this bill, but the parole hearing, the parole process that follows, what it costs a family to live through, that is exactly what this bill addresses. Her family has already faced multiple parole hearings. They will face more every 2 years for the rest of their lives. Ms. Landau will tell this committee on Wednesday what that costs a family. I will not speak over her testimony. We know the names of the men and women who did these terrible things. Their names are infamous, notorious, repeated in headlines and courtrooms for decades. Their victims' names are not. These are the names we forget. The names that history has not given the same weight as the monsters who took them. Tori, Holly, Tammy, Leslie, Kristen, Christine, Colleen, Darren, Sandra, Ada, Simon, Julie, Raymond, Sigrun, Terry, Louise, Serena, Mona, Andrea, Brenda, Georgina, Marina, and of course, Kimberly. Their families are still living with what was done to them, and they are still walking in to parole hearing rooms they should never have to enter. Together, let's pass Bill 235, and on Wednesday, Ms. Landau will tell you, in her own words, what that protection means to a family. Thank you, Mr. Chair.
Thank you very much, Mr. Kibble. Okay, we'll start the 6-minute round with Mr. Brock.
Thank you, Chair, and thank you, Mr. Kibble, for your advocacy and showing the respect where respect is due to all the victims that you've named as a result of their tragic deaths by these sadistic monsters. I especially prefer and support the title that you've created for this act. There's one area that I require some clarification. We as parliamentarians should always strive to be very clear when we're amending the criminal code. Under your bill, Section 2, it talks about where there's a conviction involving the same victim and the same event. I understand the rationale behind that verbiage, or series of events. The phrase series of events is not defined. Is there a temporal element to series of events, meaning hypothetically, can this monster decide to sexually assault a victim at one point in time, years later, months later, then abduct that same victim, months or years later, eventually kill that victim? Does this bill contemplate that scenario or not?
Thank you for the question. And the intent of the bill is that when those crimes are connected in the same series of events, not separated by years or separate at all. I'm certainly open to removing that word. The intent of the bill is for, in the case of Kimberly Proctor, it took a period of 4 or 5 days, but the events were ongoing and interconnected. So it's events that are interconnected. Certainly open to removing that word so that there would be no misinterpretation such that you've expressed. Thank you for your question.
Thank you, Mr. Kibble, for your tremendous advocacy for victims. I think I speak for all of my Conservative colleagues when I say that we believe victims should be front and center when we talk about criminal justice reforms. It's victims who have been failed by the last 10 years of changes the Liberal government has made to the bail system, the sentencing system, and the justice system. I saw in my time in media exactly what you're trying to counter here, which is families, survivors, families of victims getting dragged to these parole hearings. And there was a glee in some of the offenders because they know they're not going to get out. They know that they are never going to get parole, or at least not on this time frame, but they enjoy the power they still hold over families. And I just For anyone that thinks there is a problem with your bill, for anyone who wants to make a claim that this is not respecting, the rights of offenders, can you please just explain very clearly exactly which type of offenders are affected by this? Who is triggering this provision that you're trying to change?
Thank you for your question, Paul Bernardo. Those types of offenders. And I will further add, you said that they get glee, and pardon the term, but it's noted and been studied and documented that these types of offenders get off on re-traumatizing the victims' families. In the Kimberly Proctor case, it's even documented that they have shared their crimes in such heinous detail with cellmates that it's caused cellmates to have to seek help and be moved. So while we know, or they know that they're never going to be getting out, they actually get off on re-traumatizing the families by having a free platform at the parole hearing and to go into gruesome detail, as I said in my statement. And this is completely wrong and unjust for the families of those that I mentioned.
You did, in your opening statement, mention the names of a number of victims. One of them was Tori, and I assume you're referring to Tori Stafford. This was a case that hits very close to home. I remember when the search was on for Tori, being in a nearby area. I know that we have seen when Terry Lynn McClintock and Michael Rafferty have again tried to avail themselves of all these tools and tricks that have been given to them in the justice system. And in the case of Terry Lynn McClintock, we know that she is going to be eligible for parole in 2031. So in just 3 years, she will be, without serious change, able to do exactly what you're trying to prevent, which is start terrorizing and traumatizing families through the parole process. Do I understand that correctly?
That is correct. And if we go on the past record and the parole board's performance, these types of people, Olson, Bernardo, McClintock, Rafferty, and others, will not ever get out. But they will, as I said, get off on the gruesome detail because they know that they can re-traumatize, in this case, from a distance, but in the same vein that they did it to their victims, they're doing it to the families.
I know Tori Stafford's father, Rodney Stafford, has been very outspoken, not just in southwestern Ontario, but nationally, about how, in his words, he's been angry, re-victimized, and let down by Canada's justice system. What would it mean if Parliament were to ignore the cries from Rodney Stafford and other families who have gone through this horror?
As I said in my statement, they would feel that they're being abandoned and that Parliament would let them down. This bill has been, 4 times, and as I said, it has received, was set to pass a committee, and I hope that it passes committee again so that people like Rodney do not have to go through that again, and they can be spared that.
Thank you.
Thank you for your questions.
Thank you, Mr. Lawton. Over to you, Ms. Gladue.
Thank you, Chair, and thank you, Mr. Kibble, for being here. I grew up in St. Catharines. I lived a block and a half from where Kristen French lived. I went to school with her brother. I walked the same road that Kristen and Leslie were taken from. And to watch the torment that those parents have been put through with the parole hearings is awful. So I just want to thank you for bringing this bill forward. Now, I want to talk about a few items within the bill. The first one is judicial discretion. It leaves the ultimate decision to the sentencing judge. So why did you think it was important to allow that?
I didn't want it, and I felt, and after the consultations that I did, that we don't want to take away from our judges who do excellent work, and they're the ones that delve into the detail of the cases and get to know the families and the perpetrators and ultimately the criminals, and they're the best ones suited, with advice from the juries, to make those decisions, and it keeps it out of politics, and it keeps it solely into their hands. It keeps it out of the legislation, and we trust their discretion for the sentencing, whatever it may be, whether it's a period of ineligibility of 4 years or 10 years. this is designed to trust their discretion. And I appreciate your emotion, and I just would like to add, if I could, while there are fortunately not many of these cases in Canada, there are still too many, and you can see the impact already in our first two witnesses. They have stories that may not have affected them directly as family members, but the impact is so heinous that you're showing incredible emotion because it was from your area, you're aware of it. So imagine having to hear all of those details as a family member over and over again, how devastating that is. Thank you for the question.
Thank you, sir. Now, I want to talk a little bit about the amendments, because you mentioned that you were in favor of most of them. Some of them, there's one, for example, that is a coming into force of the legislation that would mean it applies to everything in the go forward, but it wouldn't open the door for, numerous appeals and situations from the past. Another one just says whatever we do in the criminal justice system, there's a parallel in the national defense system, and we should keep the same there. Can you comment on why you don't support those type of amendments?
Absolutely, and I appreciate your question. I'll speak to the...
Oui, et j'apprécie votre question. Je parlais de la première question sur l'aspect prospectif. L'amendement est redondant du point de vue juridique parce que la Charte, à l'article 11, interdit déjà une punition, une sanction rétroactive. Donc, toute nouvelle loi est prospective par défaut, à moins...
By default, and is already codified in the law, go forward without being retroactive. So I don't see any value in it as a pure housekeeping measure, and it would have no effect. I'm certainly not objected to it, but it's redundant in my opinion. As for National Defense Act, under the National Defense Act, courts martials don't try abduction and murders that are committed in Canada, and the core offenses, C-235 targets, are those. Military jurisdiction is limited to offenses that are committed abroad. It would certainly be worth considering a potential different bill that would address that, but would be an amendment to the National Defense Act. As far as sexual assault, that presently remains within the military. Victims have choice between either military or civilian justice systems for now, but recent legislative reform will potentially transfer that jurisdiction to civilian anyway. So the combination of those offenses that C-235, my bill addresses, abduction, sexual assault, and murder, would therefore only potentially apply for overseas cases. And as I said, that would be worthy of potential looking at separately in a separate bill, and not to conflate the two together. So thank you for that question as well.
Very good. One other amendment speaks to an ability to appeal a decision. Typically in the court system, you always have to have a mechanism to appeal, and there isn't one here. So one of the amendments speaks to adding that. And why do you oppose that?
Good question. And as far as the first one was a right of appeal for an offender, where a judge would order extended beyond 25 years. So extended parole ineligibility under C-235 already results from deliberate judicial discretion informed by a jury input. Adding an offender appeal right layers further process onto a sentence designed for most aggravated murder cases, and it would undermine the finality and potentially exposing victim families to prolonged litigation, precisely what this bill is aiming to protect them from. So the criminal code already provides robust appellate review of sentencing, and this amendment, I believe, does not fill that gap. Rather, it would create one.
Thank you. And one of the other amendments requires the judge to give the reasons if they're going to extend the sentence beyond 25 years. And this would be very helpful to basically prevent appeals that are not based on some additional information. Why do you oppose having the judge give reasons for extending a sentence?
Similar, and thank you for the question, and my answers, of course, are through you, Mr. Chair. But look, judges already provide reasons for their sentencing, whether it's 25 years, 10 years, or 40 years in the most heinous cases. This obligation is established in law, and a statutory requirement specifically targeting this provision, in my opinion, would apply a distrust of the judiciary. I think that we as parliamentarians, and we as Canadians should trust our judiciary. And they already do include it, and indeed they would give specific answers in their already required. So in my mind, it would be add procedural weight, and this is designed to be streamlined. So if the committee, I'll leave it at that. Thank you for the questions.
Okay, thanks, Ms. Gladue. Mr. Fortin?
Merci, Monsieur le Président.
Thank you, Mr. Chair. Mr. Kibble, thank you for your bill. So a question that you have brought forward is a highly important one, this matter, and I am fully behind the families of the victims who must, who are held to put themselves in positions of being victimized before the parole board and in the hearing rooms, even though I'm of the opinion that this may be a necessary or process to some degree. So I understand what you're putting forward here, that of increasing parole ineligibility, but are there any other measures, in your opinion, that could really make life far easier for the families of victims to lighten their load rather than simply increasing parole ineligibility from 25 to 40 years? Thank you for the question. And I will answer in English with your permission.
We looked at various measures and wanted to keep this very tight and targeted, such that it would provide both deterrence, although deterrence obviously considered very low and with these very heinous individuals. People have suggested things like, well, why not? Why do the families have to go even to the parole hearings? Yet families are compelled and obliged to go to give a voice for their loved ones, the victims, who are no longer able to speak. So and that's just one example, but other possibilities just do not provide the same effectiveness that we can put in this legislation. And there are other ways to mitigate it through the parole process, but legally speaking, this would be a very powerful and effective way to do that.
La Cour suprême s'est
The Supreme Court has already spoken to this matter, and I am convinced that you have carefully read the decisions, the Bissonnette case in 2022, for example, that decision in which it was stated that it would be unconstitutional to impose an accumulation one upon the other of inadmissibility periods. But in that line of thought, the Supreme Court stated that the legislator cannot sentence in a way that would reduce the possibility of rehabilitation for the offender. So rehabilitation is at the heart of our system, of our legal system indeed, and I'd like to know, from your point of view, do you believe in rehabilitation? Do you think it's possible and ideal? And in some cases, of course, it may be impossible.
Thank you, and it's a fair question. And yes, I do believe in rehabilitation. And more importantly, I believe that criminals found guilty should have the opportunity for rehabilitation. In the Bissonnette case, which was struck down, it was for parole ineligibility periods of 50, 75, and even 100 years. It's very different. And in this case, as I alluded, or as I spoke to in my presentation, and in this case, it's just a combination of the total, so that's why we arrived at 40 years. There is opportunity for rehabilitation. And furthermore, this was modeled after Bill C-48, the Protecting Canadians by Ending Sentence Discounts for Multiple Murder Acts, which also extended ineligibility, and it did survive a charter challenge. So in the scope of the 40 years, it has survived a charter challenge. It is a long distance from the 75 and 100 years within the Bissonnette decision. It allows for the possibility of rehabilitation, however unlikely it may be in this case. I do agree that that is a valid requirement for the possibility of rehabilitation. Thank you.
Si on pense que la réhabilitation,
If we think that rehabilitation is possible, doesn't it seem to you that it is not merely legitimate but desirable that there be fixed periods after which the situation could be evaluated? Has the offender become more eligible for parole? Might they be rehabilitated? Because 25 years is quite a long period of time. And being eligible at 25 years and then thereafter every 2 or 5 years, depending on the case, this would make it possible to tell whether rehabilitation had become possible. Doesn't that seem wiser to you?
Thank you for the question. Indeed, possibility was what I said, possibility of rehabilitation. Regardless, it's not for me to decide what that is. That's what judicial discretion is for, and it allows the judges who know these types of cases, who know these types of offenders. They're the ones that make those decisions, and I think we should all put our trust in the judiciary to do that. And you said that 25 years is not a long time. It's actually 23 years is when they can first apply if they're given that. For every two years. But these are the criminals. These are the ones that have taken away the lives and that have lasted for more. They're the lives that are lost for more time than 25 years. And if you're a family member, that 25 years is not very long a period for grieving. And as you approach the 23-year period, even in advance of that, preparations, as you will hear on Wednesday, preparations in approach of a parole hearing is not just something they turn up at the last minute. There's decisions are made, letters are received, preparation of statements, so it consumes a very long period of their life. And but to summarize, that's not, I don't think, up for us as parliamentarians to decide. That should be with the judiciary.
Thank you, Mr. Fortin.
merci.
Mr. Gill, to you for 5 minutes.
Mr. Chair, and thank you, Mr. Kibble, for introducing this important bill. As the Member of Parliament for Brampton West, every week I'm hearing more and more from victims of violence in my community. Violent crime is on the rise in my community and across the country. Extortionists, murderers, gangsters act without consequences. I know I'm not the only member in this room who regularly hears from constituents concerned about the liberal crime crisis. It is now very important than ever to put victims first because this government has not for 11 years. Our job today is to work together to put victims ahead of criminals for a change. That's why Bill C-235 is so important. And I will turn to Mr. Kibble. Do you think we neglect families in the trial process? Mr. Kibble.
Thank you very much for your question. It was just taking a note. And I agree with your assessment of crime across Canada, and you gave some various examples. This bill specifically deals with the most heinous and gruesome criminals, and is focused very much at that. But I do agree that victims and families should be put ahead of criminals, and I believe very much that this bill does exactly that. And yeah, I don't really know what else to say beyond that. It certainly, that is the goal, and I think that it will achieve that. We've seen that also in Bill C-48. And as far as you said about crimes, in the court process of protecting families, though not related to this case, my own daughter's boyfriend was murdered, and I went through and went with her to trial every day for a fairly long period. And the courts were very sympathetic and supportive. But the process can be particularly challenging on families. I have a small window in what the types of families are dealing with in these types of cases, and I wouldn't begin to imagine what they're going through So regardless of the supports there that you receive and the sympathies that you receive from the Crown and defense prosecutors and the understanding that they go to give, and so I'm not knocking them in any way because they are positive, it still can be particularly tough on those families regardless.
We know crime of any nature has devastating impacts on families and their loved ones. Is this about everyday cases, or it's about worst of the worst?
Yeah, a short answer, worst of the worst. Clifford Olson, Paul Bernardo, and so on. So this is, as I said, and I would like to repeat, fortunately, there are not many of these cases in Canada relative to other crimes, but I think that the impact, as Ms. Gladue showed, is huge to so many people across Canada, and this would help bring that support to the families.
Thank you. We know the Supreme Court's habits of finding mandatory minimums cruel and unusual in fringe cases. Could you see that applying here?
Perhaps you could define for me what a fringe case is. I am not a lawyer, but I'm thankful that there are not many of these cases, although everyone is too many, and they would all be unique, but I'm not quite sure what you mean by a fringe case.
Okay. I'll move on to my next question then. The Bissonnette decision basically allows murderers to get discounts on additional murders or on other crimes. Why is it important that murderers face justice for all their crimes?
Sorry, say the last part. Why do murderers face?
Why is it important that murderers face justice for all their crimes?
Under a judge's discretion, I think there are many cases that sentencing should be consecutive. And unfortunately, we've seen in a few other areas this has not been approved in the House. For example, consecutive sexual assaults. I think that they should be consecutive. And it has to be a balance between deterrence, justice for victims and families, and also allowing the possibility, however slight it might be, of rehabilitation. And I believe that Bill C-235, although it may sound harsh, based on the harshness of those cases that we've described, that it finds and meets that balance.
Okay. Thank you, Mr. Gill. Thank you. Ms. Begum, you're up for 5 minutes.
Thank you very much, Chair. Thank you very much, Mr. Kibble, for coming in today and for introducing this legislation. I think, I echo the sentiment of Ms. Gladue and the many others in regards to how important it is for us to have a strong sentencing regime for offenders, and you've named a few, and I just want to say I really appreciated how respectful you are to some of the victims and the way you've highlighted that. I think it's really important that we pass any legislation with as much scrutiny and care as possible, and allow for it to do justice. And that's just unintentional play on words. But one of the things you talked about in terms of judicial reasoning, you actually, before I go into that, I'll speak a little bit about what prospective application, and you mentioned that prospective application provision is redundant in your introduction, and I wanted to ask, if it changes nothing legally, what is the concern with providing additional clarity and certainty directly in the bill?
Thank you for your question. I appreciate your very good play on words, and I also couldn't agree more that any new law needs to be taken seriously and scrutinized, such as that we're doing through this process and in committee and with our witnesses for the next hour. But I have nothing against putting in about an amendment to making it not retroactive. It just simply is redundant and potentially risks setting a precedent for some other case. So or law. I don't think that it is worth putting in, and perhaps our departmental witnesses could better speak to that. But to me, it's already a law. It is not retroactive, and so therefore it would simply be redundant to put in. It would keep the legislation cleaner. But thank you for the question.
I understand that Parliament regularly includes clarifying provisions in criminal legislation. So I wanted to ask, why should this bill be treated any differently?
Treated any differently than what?
Any other legislation in terms of, clarifying and having something that is put in concrete order, and I think also charter challenges and anything, because this bill, even to me, I feel it's so important and what it aims to do, and I really salute that effort. I hope that we can help make it even stronger. So if Parliament can play a role in clarifying some of these provisions and making it better in terms of having this legislation, shouldn't we do that?
I'll state the agreement, and thank you for the question, is legally redundant. Charter Section 11I already prohibits retroactive punishment, and all new legislation is prospective by a default unless it explicitly states otherwise, which this bill does not. Codifying prospectivity on the face of the bill could invite litigation over the line between clarification and limitation, potentially narrowing the bill's reach in ways parliaments may not have intended. So that said, if the committee views it as a pure housekeeping and important measure, while it has no substantive effect, I don't have a serious objection to that.
Thanks so much for that. Thank you for stating that. I have one more question, which is, you've said that judges already provide reasons for these decisions, and if they already do, I guess, what harm what is the harm in making that expectation explicit in the legislation? And
fair enough, and I appreciate your question. And as far as mandatory reasons in a decision, a judge already provides reasons in the sentencing. It's an obligation that's established in law, and a statutory requirement specifically targeting this provision implies distrust of the judiciary, and it may invite formulaic compliance rather than genuine deliberation. And it also adds procedural weight to a mechanism deliberately designed to be streamlined and victim-centric. So if the committee finds, comfort in making this explicit in the language, it certainly would have to be very carefully drafted to avoid constraining the very judicial system the bill was designed to create. I feel that it is not necessary, and it would certainly be a fair question to pose of our departmental witnesses.
Thank you, Ms. Begum. Mr. Fortin, over to you for 2.5 minutes.
Monsieur le Président.
Thank you, Mr. Chair. Mr. Kibble, statistics that I see before me tell us that people who are serving sentences in perpetuity represent about 10% of decisions brought before parole boards, and of that 10%, only 27% actually do get parole. I don't have any absolute numbers, but that seems to be a small number. In the current system, they necessarily serve 25 years. At the end of 25 years, the parole board will study whether there is or there is not any reason to hear them, whether they should deliberate on this, and 27% of that 10%, that's not a high percentage. Doesn't that seem sufficient as, let's say, a safeguard against putting out on parole people who have committed heinous crimes?
Thank you for your question, and through you, Mr. Chair, I'm not here to second-guess what the parole boards do. They're very capable at making decisions. And in this case, and you said 10% and 27%, but these cases that I'm speaking about is a very small percentage of those. And of the research we've done, we were not able to find any that the parole board has allowed to be set free in this very tight, narrow scope of crimes. Again, it is also left at the judge's discretion to come up with the correct sentencing that would allow for when a parole would be eligible. There may be cases where it would only be 12 years, and I would respect that judge's decision.
On est d'accord, M. Kibble, sur le fait que les tribunaux, moi aussi, j'ai
Very well, we agree, Mr. Kibble. I'm 100% in agreement with you with regard to the court's wisdom. I just tend to try to ensure that the offenders' points of view are covered as well. Now, earlier, you said that you did believe in rehabilitation. Do you think that shifting from 25 to 40 years, the period of parole ineligibility, so adding an extra 15 years behind bars, will increase the possibility of rehabilitating more offenders?
Thank you for the question. It's a bit loaded because, as I said, in these cases, as we've seen, the parole boards have not found any of them to be suitable for rehabilitation. Yes, so 25 to 40 years. Look, if somebody had committed these crimes independently, all in a row, a different victim, over the course of a week, they would get 40 years. But in this case, because it's all the same victim at the same time, they drop the abduction, they stay the abduction, they stay the rape, the sexual assault charge, and they just prosecute the one. So, because they're all connected. So, yeah, they would be getting 40 years if they were separate cases. But because this is all in one, it's only 25 years. And again, and I'm glad to hear your agreement, and we have a solid agreement here that we do trust the court's wisdom, the judiciary, with input from the judges as to decide when that opportunity for rehabilitation is. And I will leave it to the judiciary discretion and then the parole boards to make those decisions.
Mais
Thank you, Mr. Fortin.
Merci, M. Kibble. Merci, M. Président.
Mr. Baber, over to you for 5 minutes.
Committee, and thank you for bringing this bill forward. I did not know that someone related to your family has experienced a personal tragedy. Please accept my deepest condolences on behalf of all of us at this committee, our staff, and everyone that helps us work here at least twice a week. Mr. Kibble, I want to understand the nature of your proposal very clearly. So for those that are convicted of an abduction, sexual assault, and murder in the same event or in a related event, your bill will allow the court the discretion to increase parole ineligibility from 25 up to a maximum of 40 years. Is that correct?
Thank you, Mr. Baber, for your kind words and thoughtfulness. It means a lot, and I appreciate that. Yes, I will just add that it also requires the same victim.
Of course.
And so guilty of abduction, sexual assault, and murder in the same incident, absolutely, then it would be a judge's discretion to determine in the specifics of that case the length of parole ineligibility. Regardless, they're always a life sentence.
I may confirm the reason for the bill is to essentially limit the exposure of victims' families to persons who abducted, assaulted, and murdered their loved one from showing up at a parole hearing and potentially be re-victimized again by hearing an account from the convicted murderer. Is that correct?
Absolutely. And as I alluded to earlier, really for these types of heinous criminals, there is little deterrence. But the focus, if I could just finish quickly, is absolutely on the families, which is why in my statement I focused on the impact that it has on the families. I'm going to a parole hearing, an unrelated case, to support a constituent, and we'll be able to experience some of the trauma that he's experienced. But you're absolutely right. The focus is on the families and preventing the re-victimization and bringing the families not just back to the parole hearing where they're in the same room as this heinous criminal, but they have to hear in gruesome detail from someone of what they did to their loved one who has no voice anymore. And those heinous criminals, as I stated, get off on sharing those details as gruesomely as they can to impact the families.
Thank you, MP Kibble. I want to go through some of the mechanics here. As far as I understand, in cases of first-degree murder and high treason, the criminal code provides that the offender must serve at least 25 years. And as for second-degree murder, the period of ineligibility actually ranges from 10 to 25 years. Now, if I understand your math here, the maximum of 40 years was determined by looking at the maximum ineligibility for each of these three offenses separately and adding them together to be served consecutively rather than concurrently. So for murder, it is 25 years without parole. For abduction, it is 10 years. For sexual assault, it is about 4.5 years without parole. So that's a total of just under 40, so 39.6 years, and hence the 40 years. Is that the thinking here, to essentially have the parole eligibility run consecutive for those three heinous offenses?
Yes. Thank you for putting that together, and I appreciate your excellent math at 39.6 years that we rounded to 40. And as I answered earlier, if someone had committed, a criminal had committed those three crimes separately, one day after the other with three separate victims, and they were found guilty in all three, they would be facing that type of time in potentially up to, of course, a judge's discretion. And, of course, second-degree murder and high treason certainly don't apply in this bill.
I want to confirm in the little time that I have left, Mr. Kibble, this is not about mandatory minimum sentences. And it's about parole ineligibility. And there is no concern here that there's going to be compliance issues with Section 12, which is cruel and unusual punishment. And to add to that, we are dealing with the worst of the worst in society. We're dealing with the Paul Bernardos. We're dealing with the Olsons. That's who we're targeting here. We're targeting the worst of the worst to protect families of these victims from being re-victimized. I'll give you the final word.
Thank you, and I appreciate that there's little time for my answer. I'll be very concise. This is not about mandatory minimums. These are people that are getting a life sentence. They may never get out. It's just the parole ineligibility period. It has passed the charter challenge as it is modeled after Bill C-48, and yes, it is the worst of the worst. Thank you.
Thank you, Mr. Babber. Mr. Housefather, to you for 5 minutes.
Thank you very much, Mr. Chair, and thank you very much to Mr. Kibble for bringing forward this bill. And I also want to extend my sympathies to you for the tragedy that your family also have suffered. I had not known that either, but I share Mr. Babber's condolences. So I actually sat on this committee in 2019. I chaired it when James Bazan's, I think it was S-266, came forward and supported it then, and I support it now. I guess I have two questions. One, Mr. Kibble, you seem to be reluctant to support the amendments that I think were shared with you that various members had suggested. I understand the goal of a cleaner bill, but if the bill amendments create certainty for other people, and certainly don't interfere with the overall objectives of the bill in terms of changing the thrust of it, which is that juries can recommend to judges and judges can decide on longer parole and eligibility periods. Do you have an objection based on substantive grounds, or are they just, you don't think they're needed and you just would rather the bill be cleaner?
Thank you for your question, and I very much appreciate your kind words, and I have much respect as well for chairing the committee previously and working on this bill, so you would have a very solid knowledge. And thank you for signaling your support. Your question refers to amendments. I'm certainly open to amendments. For me, it's very important that procedurally and legally it is done the correct way. So that's what I would want to support. I believe that some do interfere with the process, but I would defer, and it would be best to ask those questions to the departmental experts. And I'm certainly open to amendments, not that would provide certainty for parliamentarians, rather that would provide accuracy as recommended and procedurally correct from departmental officials. I certainly am open to that. And if that is what it takes to get certainty for our parliamentarians, I'm certainly open and flexible to that. I've offered my assessment of those, of what I've been able to research, not as a lawyer, but as a former naval officer. But I certainly will defer and be very open to any potential improvements, corrections, or accuracy that departmental witnesses could provide. Thank you for your question.
No, that's an excellent answer, and also thank you for your service. I hadn't realized you were a naval officer, but that's very impressive. And I think you're right. We have to ask these questions to officials, and officials can then clarify, whether or not those amendments make sense in the context of the bill. So totally agreed. So I want to just give you one other question. One of the things that our committee had done in the period between 2015 and 2019 was an entire study on juries. And the jury is an incredibly important part of our system that is often overlooked. Can you talk to us about what your view is about the importance of jurors making recommendations to the judge in this context, and the place of juries in determining, as an average Canadian, what someone's sentence should be?
Excellent question, and I thank you for that. And as someone who sat through a trial that has touched my family and seen and learned the process of a jury giving a recommendation, I think it's hugely valuable. They are generally not, the jury members generally don't have a legal background, but they're a temperature for the community, and I think it is very important what they provide. I know that there's been suggestions of some that have said, oh, this should only be, or discussions should only be the judge that would do that. I think the jury input is important, and the judge, of course, has, as you know, the ability to determine exactly the period of ineligibility, but he takes and considers the input after very detailed instructions to the jury. And having seen that process, I think it's a very valuable process, and should certainly continue. And I support that fully.
Completely agreed. Thank you, Mr. Chair.
All right, thanks, Mr. Housefather. Look, we have 5 minutes left in the first hour. I'm proposing we give 2 minutes to each party and give Mr. Kibble further opportunity to speak to his bill. So we'll start with Mr. Brock, and then Ms. Latanzio, and then Mr. Fortin. So 2 minutes each.
Thank you, Chair. Mr. Kibble, you indicated during your opening remarks that this has gone through several iterations over the last few parliaments, and one you indicated had actually passed with government approval, but was shuttled because of prorogation. The content of that previous bill, is it identical to your bill?
Drafted it a fairly long time ago. There had been some minor amendments as it went through the legislators, but they were small and technical, so it's nearly identical. It was been C-266 in the 40th, 296 in the 41st, to C-47 in the 41st as well, and ultimately
I appreciate you're not a lawyer, but I'm going to ask the question nevertheless, because I don't know about any consultations you've had with any constitutional experts or anyone from the DOJ. This is largely dovetails about a response to the Bissonnette decision, that horrible decision from the Supreme Court of Canada that ruled that particular monster's sentence in the circumstances was ruled to be contrary to Section 12. The Supreme Court of Canada, however, did not rule on whether the imposition of any period of ineligibility exceeding 25 years was unconstitutional. And that's precisely what your bill is attempting to address. How confident are you, given the fact that, as you indicated, you're not a lawyer, but based on the consultations you had, how confident are you, sir, that this is going to pass constitutional test?
I'm fully confident, and thank you for the question. It is modeled after Bill C-48, which did pass a constitutional challenge. And from my colleagues and lawyers and people that helped us work on this bill and through its previous iterations, I am very confident that it will pass any potential charter challenge. Thank you for the question.
Mr. Kibble.
Thank you, Mr. Brock. Ms. Latanzio?
Thank you, Mr. Chair. Thank you, Mr. Kibble, for bringing forward your private member's bill. I think there's a broad agreement around this table this morning with regards to the objective that you're seeking with your private member's bill. As legislators, as you know, our responsibility is to pass legislation, but not just to pass it, but to pass it and ensuring that it works as intended and ultimately stands the test of time. Would you agree that there are opportunities, if there were, to strengthen the framework without changing the substance of this bill? This committee should seriously consider them.
Thank you for your question, and absolutely I would, as I said earlier, when I spoke against some of the amendments, was to make it correct, and if there's something that is going to make it better, stronger, and it's not just somebody's crazy idea, but actually a solid, recommended, proven, debated amendment that would achieve the goal of protecting families, which is ultimately the goal here, then absolutely I would consider that. And I think that's very important, and would be foolish not to do that. We've tried to consider everything in the drafting of this, production of it over many years. But if there's something that could make it better, then by all means, yes. And thank you again for signaling your broad support for our objectives here.
Okay. And last question to you. Would you agree that there is a difference between an amendment that would change the policy and the intent of the bill and an amendment that simply helps ensure the bill achieves the intent in a legal and sustainable way?
Yeah, I'm not exactly sure how to answer that, but I would say anything that will make it better to achieve the objective, if there is, without broadening the scope of it, because I think then that would get into a whole more complicated process. It would keep it tight to the scope of the specific crimes and circumstances of this, and it would make it better for achieving results for the families. As you will hear the impact on Wednesday, then certainly open to discussing and making improvements if required.
Thank you, and I understand.
Thank you, Ms. Lebeda.
That's it?
Yeah,
Okay.
yeah. Mr. Fortin, you have 2 minutes.
Merci, Monsieur le Président.
Thank you, Chair. Mr. Kibble, you have just stated that, in your opinion, your bill would survive a charter challenge, but should that not be the case, would you think that we should use the notwithstanding clause that is provided for in the charter?
And thank you for the question. I do believe that it will withstand a charter challenge. And as far as speaking on notwithstanding clause, that would be something that would be above. It would be a government-wide or a party-wide consultation to determine the best path forward. But I am confident that this will, as C-48 did, withstand a charter challenge, and we'll cross that bridge if we get there. But I don't expect we would.
Et dans l'éventualité où ça ne...
And should this fail a charter challenge, do you have any other measures that you could put forward to better mitigate the effect of the various parole hearing procedures for the families of victims to prevent them from having to come in to testify? Would a written document, a written testimony suffice? There might be a number of ways that could be used to modify the process to respect the needs of families and of victims, but that nevertheless allows a parole request to go forward before the board. So what do you think that would look like?
Thank you for your question, and modifying the process to help families outside of legislation only covers part of what this legislation does. And that would certainly be an independent project that I'm sure people are always considering and looking at. But this, and let's stay focused on what this is legislation about helping the families, providing potential deterrence, ensuring that all three of those charges would then be answered for and dealt with in court and not just stayed. So there are other processes, and they're independent and separate of this. We're staying focused on this particular process so that we can help victims with something that was within our powers. And if parole boards or other organizations look to help families, then I commend that as well. But I'm staying focused on this particular mission here.
Thank you, Mr. Fortin.
Merci, Monsieur Kibble.
Mr. Kibble.
Thank you, Mr. Kibble.
Very much for, first of all, presenting this bill, but let me add my voice to thanking you for sharing your personal stories, and my sympathies to you and your family. We're very grateful for your time, but we will suspend now for a few minutes and bring in the officials. Thank you, Mr. Kibble. right, welcome to the second hour of the meeting. Today, we are joined with two familiar faces from the Department of Justice. We have Joanna Wells, Senior Counsel and Team Lead, Criminal Law Policy Section, and Aaron Kelly, Legal Counsel. Thank you both for being here today. I understand you do not have any opening remarks. Okay. All right, so we'll jump right into questions, and we'll start with the 6-minute round with Mr. Gill.
So thank you, Mr. Chair, and thank you to Justice officials. My question is, this is the fourth version of this bill. It's been trying to pass Parliament for the last 15 years. Every time it is overwhelmingly supported. Why has the department not taken the initiative to include this in government legislation?
Question, Mr. Chair. As the committee knows, questions about what goes in or what does not go into government legislation are decisions that are made by the Minister of Justice. It is not the department officials that decide one way or the other to include these.
So don't you think Minister of Justice didn't feel the need of this to be added?
Can't speak to what the minister did or didn't feel. It was not part of the, it is, and you know this well, having studied the bills fairly recently, this initiative does not form part of the any of the government bills, but is part of, it's on Parliament's agenda to be studied.
In 2019, all members agreed that this bill respected both judicial discretion and Section 12 of the Charter. A lot has changed on both those subjects since 2019. We are in the worst phase of criminal activity in our country. Mr. Kibble has stated that in the House that this bill respects those two concepts. Does the Department of Justice believe that is the case?
Sorry, Mr. Chair, if I could ask for just could you reformulate the end of the question? I missed the question at the end, Mr. Gill. I apologize.
So I will repeat it again. In 2019, all members agreed that this bill respected both judicial discretion and Section 12 of the Charter. A lot has changed on both subjects since 2019. We are in the worst phase of criminal activity in our country. Mr. Kibble has stated in the House that this bill respects those two concepts. Does the Department of Justice believe that is the case?
So I can speak to the concepts in the bill. It's certainly we would agree that there is judicial discretion proposed in Bill C-235 with respect to whether or not to increase parole ineligibility. And you are correct that the landscape on Section 12 and parole ineligibility has changed since 2019 with the release of the decision in Bissonnette. And so the department is of the view that any change to parole ineligibility would be closely scrutinized by the court under the Charter.
Okay. Does the department have numbers as to how many cases this would impact per year?
Okay. Thank you for the question. We don't have exact figures on per year how many people this would affect. I can tell you the latest figures we have is from the period of 2000 to 2020, and there were approximately 26 offenders in CSC custody that would have fit the fact pattern considered in this bill. And in that period, 6 new offenders had entered custody.
Has there ever been a case where a criminal who would fall under C-235 has been granted full parole?
Those kinds of questions are not within the expertise of the Department of Justice. That would be something that would be in the purview of our colleagues at Public Safety or Correctional Service of Canada.
This bill would require a jury to recommend a higher sentence. If a jury imposes a higher sentence, does that reflect a public view of how evil these crimes are?
It's fair to say, and one of the reasons why juries are such an integral part of the criminal justice system is because they do provide the peer review, if you will, in a criminal case. And so the bill mirrors the approach that exists in the criminal code already to allow a jury who heard all of the facts to make a recommendation so that a judge could consider. I think you could view it as sort of the public input into what the appropriate sentence would be, but that particular small set of the public who heard the facts of the case.
Judges are not bound by a jury's recommendations. Would you expect a judge to not impose an unconstitutional recommendation?
Judges would have the discretion to make the sentencing decision, and they would be well aware of the decision in Bissonnette when they are making those decisions.
Okay. That's it for mine.
Thank you, Mr. Gill, which takes us to Ms. Latanzio.
Thank you, Mr. Chair. Thank you, officials, for being with us here today. Clarify a few questions we have for you with regards to this new P&B. Officials, we heard testimony this morning suggesting that this P&B raises little or no charter concern. And I wanted to have your opinion on this. Given the Supreme Court jurisprudence that we've cited this morning, the Bissonnette case in particularly, regarding the lengthy parole ineligibility periods, would it be fair to say that this piece of legislation extending parole ineligibility to as much as 40 years would attract charter compliance and scrutiny?
Yes, it's fair to say that this would likely have some charter scrutiny. There are serious liberty interests at stake, and it is extending the punishment beyond what is currently allowed under the code. So in light of what happened in Bissonnette, we would expect there would be some charter scrutiny.
The Supreme Court has emphasized the importance of maintaining a meaningful possibility of release. Could you explain why the principle is relevant when Parliament is considering increasing parole ineligibility from 25 to 40 years?
Thank you for the question. So the court in Bissonnette was clear that the door needs to be left open for some possibility for rehabilitation. So it is important, and I will say an important distinction between what is proposed in this bill and what was at issue in Bissonnette is the level of discretion that is afforded to judges. So in this case, judges do have discretion to put a sentence within a range of 25 to 40 years for parole ineligibility period, which would allow them to appropriately tailor the final sentence in a way that would respect constitutional principles.
Do you see any issues with that?
I can really only point to what the court has said, and it would be for the court to look and scrutinize this law accordingly should it be challenged.
Okay. We have heard the provisions clarifying the prospective application may be redundant. This is what the testimony revealed this morning because of existing legal principles that we have in place. From a drafting and implementation perspective, what value, if any, is there in including clarifying language directly in this legislation?
So I'll say it's not unusual to provide clarifying language, especially in scenarios like this, where this would be a very serious punishment and a change to the code. The common law is quite clear on how legislation would apply if there is no discussion on the temporal application, sorry. So in this case, like the courts would assume a prospective application if the law is otherwise silent. The committee may still wish to consider whether further clarification in the bill would be helpful.
The testimony also this morning revealed that there were other versions of it brought forward before Parliament and the committee. And a witness explained to the committee that the difference is only technical. Is that your opinion?
If I may ask a point of clarification, the difference between
the previous drafts and this one, to your knowledge, would it just be technical differences?
So in our view, the substance of the bills is the same, and the intent is the same, whether or not there were minor amendments. I haven't done a side-by-side comparison, but our understanding is the objective of the bill is exactly the same.
Okay. Would it be fair to say that measures such as appeal rights, judicial revisions, implementation clarifications are not about weakening the bill's objective? Rather, it is about ensuring that legislation is complete, transparent, and legally robust?
Yes, I think it's fair to say procedural safeguards that could be added to this bill would not impact on what we understand the core objective of the bill to be.
Thank you.
Mr. Fortin.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Thank you, Ms. Wells and Ms. Kelly, for being with us here today. And you may be unable to say, but do you have information about the number? I heard 26 earlier. I'm not sure which report from, but the number of cases of persons who would be affected by shifting from 25 to 40 years the period of parole eligibility. It was 26 in a specific year?
There were 26 offenders in the custody of the Correctional Service that would have fit the fact pattern of the bill. That doesn't necessarily mean they were convicted of all three elements that would be required in the bill, but the fact scenarios of their crimes would have fit that pattern had they been convicted of all three.
Et à votre avis,
And in your opinion, given the prior decision made by the Supreme Court, I understand that there is a difference between the Bissonnette decision and what's being put forward here, but there are some similarities. So, in your opinion, do you think it would make sense to use the notwithstanding clause to have this bill carried to protect it from an eventual review by the Supreme Court?
So this government has not stated any intention to use the notwithstanding clause in relation to this bill, and we cannot comment further on that.
Oui, mais je comprends. Puis je vous demanderai pas votre avis.
Yes, I understand that, and I'm not asking for your personal or political view on this matter, but rather your view as legal experts. Could this type of bill could it benefit, and wouldn't it be easier to carry it if there were a notwithstanding clause included in it simply on the legal basis? I'm not asking you to provide actual legal advice to the minister at this point, but legally speaking, couldn't using the notwithstanding clause protect it from any review by the Supreme Court?
Clarification. So, as my colleague indicated, this government has not on record of wanting to support this bill using the notwithstanding clause. The federal government, as you know, has never invoked the notwithstanding clause with respect to federal legislation, but it does remain a legal tool available should the committee feel it's an appropriate use of 33.1 of the charter to limit charter scrutiny of this particular provision.
Et à votre avis, est-ce que le projet de loi, dans sa mouture actuelle,
in its current form, does this bill meet the requirements? I mean, would it really stand up to a charter challenge? Would it be found constitutionally valid?
We have indicated we expect, and as the committee seems very alive to, that this bill, should it pass, would definitely receive significant judicial scrutiny. We know because it's a penalty that comes, post-conviction for a murder, that the likely charter lens will be under Section 12, and the decision in Bissonnette from the Supreme Court would very much guide the consideration. We can't provide any more than that to the committee, but it certainly is, certainly would be novel.
No.
Novel.
Et si on...
And if we are of the opinion that rehabilitation is possible, wouldn't you think that shifting from 25 to 40 years, the time period for parole ineligibility would be unreasonable?
Discretion between 25 and 40 years. So a judge could find that 26 years would be appropriate or 27 years. It wouldn't automatically be 40 years. And the difference, as my colleague indicated earlier with the Bissonnette analysis, was that in that case the court was looking at 50 years as the floor, as the starting point for the next period of parole ineligibility. So there are significant differences here with respect to the discretion and the time that the court could order the offender serve.
Et est-ce qu'il existe d'autres mécanismes présentement?
And are there any other measures currently available in our legal toolkit to accompany or better protect the families of victims when there are hearings for parole, to your knowledge?
The question you're asking is whether or not there are supports for victims with respect to attending parole hearings, and yeah, so those again are not within our expertise, but in our understanding there certainly are lots of supports available for victims should they choose to attend parole hearings. I understand that's not the intent of the bill, which is to eliminate the parole hearings, but there are existing measures in place to support, yes.
Merci.
Thank you, Mr. Ford. Okay, we'll go to Mr. Brock for the beginning of the 5-minute round.
I want to start, thank you, Chair, and thank you to the officials for being here. I want to start with just a general observation. And I often hear it, particularly at this committee, when I hear from department officials. Anything that we do as parliamentarians with respect to any amendment in the criminal code will always be subject to charter scrutiny. We should never abrogate our responsibilities or shy away from pushing the envelope in terms of addressing what Canadians want us to address. And I think it was well put by Mr. Lawton in the opening round. You know, this country has seen 11 years of a complete removal of any consideration of victim rights. I'm not going to repeat myself because I've repeated it numerous times. But in my view, anything that we do will be subject to charter scrutiny. So with all due respect, Ms. Wells, to your comment to Monsieur Fortin, that any charter challenge, particularly in the area of this particular private member's bill, that the Bissonnette decision would influence anyone bringing a charter challenge. And I want to point out that Bissonnette specifically dealt with the stacking element of parole ineligibility. Paragraph 71 of that decision specifically did not rule on the imposition of any period of ineligibility exceeding 25 years as being unconstitutional. They simply were not asked or were not presented with that particular argument. The two pillars as to why Bissonnette was ruled to be unconstitutional is that it did not provide a realistic prospect of a release within the context of human dignity, and it completely negated the whole concept of rehabilitation, when in these circumstances, rehabilitation would rank among the lowest of all sentencing considerations. Bill C-235 includes human dignity components, talks about a realistic prospect of a release, and certainly talks about rehabilitation. So given that has been altered with 235, are you still confident that this could receive not only significant charter scrutiny, but would be successful as being contrary to Section 12?
Your mic's not on.
So sorry. I think we would still expect there would be significant charter scrutiny. This is a very serious penalty. It would expand beyond what is currently the harshest penalty under the criminal code. So in light of those factors, we do still believe it would be scrutinized. Whether it would, pass a constitutional challenge would really be up to the courts. I think Ms. Wells and I have both mentioned the key distinguishing factor in this case being the level of discretion that judges have, and I think that would be a key consideration in a charter challenge under Section 12.
Thank you, Ms. Kelly. Would your position still be the same if this were a government bill?
Is that, if I may ask for some clarification? Sorry,
Well,
my mic's-
if you had to put together a charter statement, would your commentary today be the same as the commentary you would provide in a charter statement had the government introduced legislation along these lines?
I can say with respect to that, Mr. Chair, is that any charter statement that would be prepared by the government with respect to this would analyze the proposals in Bill C-235 through the lens of Section 12, and in doing so would use the analysis in BCNET to guide it.
Is that a yes?
To
Your
guide its
position would be the same?
analysis, and the elements that you pointed out, Mr. Brock, as being different would certainly be considerations that would factor
Again, my
in.
time is limited, Ms. Wells. Is the answer yes? Your position today would be the same to the Minister of Justice should he have decided to bring this type of legislation? Yes or no? Simple question.
So it can't be a yes or no question because we are unable to provide advice to anyone other than the minister, including to the committee. So I think my answer stands, as I said it earlier, that would be the lens through which it would be analyzed, Section 12.
Have you done a comparison to any other common law jurisdictions that have a similar type of approach to expanding parole ineligibility?
The comparison that we've done in international jurisdictions looks to penalties for murder, and Canada is amongst the harshest with respect to the penalty for murder.
Sorry, I didn't mean to cut you off. Thank you, Mr. Brock. Ms. Gladue.
Thank you, Chair, and thank you to the officials for being here today. In our earlier testimony, we heard that the amendment we'd like to bring to put a coming into force date to make sure that people are not going to fill the courts with, previous convictions. The witness told us that it's redundant because Charter 11.1 would prevent that. But my understanding is that, if you hoped it would happen and it didn't, and you did a charter challenge, that would take a long time. Is that fair?
So there is a common law presumption against retrospectivity, meaning essentially when a law comes into force, especially with regards to punishment, it is assumed to apply prospectively and would not have retroactive application. So courts in applying the new legislation or applying this bill would look to that common law presumption, and they would look to Section 11I and 11H of the Charter and apply it accordingly. So it would be less about necessarily a challenge on the basis. It would be more about the guiding principles in the Charter.
Thank you for that. Another discussion we had was about trying to make sure that what we put into the criminal code is matched with the same things in national defense. Is that kind of an amendment within scope of the bill?
Thank you for that question. As departmental officials, questions of scope do not fall within our area of expertise. Those are questions certainly for the committee. It's something that, since you've asked, all I can say is that the Bill C-235 doesn't propose to open the National Defense Act, and so the committee would likely turn its mind to whether or not it is within scope, but will also flag that there are parallel amendments in the National Defense Act for murder. So you may just want to turn your minds to that.
That's very good advice. Thank you. One of the other things we were hoping for is that we could amend the bill so that the judge would be able to provide reasons why they picked, a longer time, be it 26 years, 27 years. Why was it 27 and not 40? Why was it 40 and not 27? Thinking that perhaps that would not only give clarity to the victims' families, but also in terms of appeals. Is this something that appears in other types of legislation?
It does, so there is a common law requirement for judges to provide reasons. Where I might draw, a distinction here is that for first-degree murder, currently it is an automatic life sentence and an automatic 25-year parole ineligibility. So currently, there's not much to appeal on those grounds, as this would provide judicial discretion for a longer parole ineligibility period that is allowable currently under the code. It may be a helpful signal to the courts to ensure that reasons are well documented and set out. So we would, leave that to the committee to consider.
Thank you so much, Chair. I see the bells are going.
Yeah, I was just, you beat me to the punch. The bells are ringing. We would need unanimous consent to continue if we were to do that. Do I have unanimous consent? No. No. Okay. Meeting adjourned.